Keep we island clean.
From the streets to the beach. No dirty of Jamaica. Please don't do it.
No dash, no paper, no dash, no plastic. Dispose your garbage responsibly. No know how to recycle, learn it, pick, and if you drop it, better pick up every piece of it.
No dirty of Jamaica. No dirty of Jamaica. No dirty of Jamaica. No dirty of Jamaica.
Let's pray. Father, as we come together this afternoon to deliberate on matters concerning this committee and by extension our country, we ask for your guidance. We ask that whatever we shall do in this exercise will be of benefit to all of us and to our country. We ask for journeying mercies for those who are on their way. These and other mercies we ask in your name. Amen.
Thank you. We have apologies for absence from Ms. Dalrymple Philibert, Ms. Cuthbert Flynn, and Senator Samuda, Ms. Cuthbert Flynn and Senator Samuda are away. All right, we will move right into our clause by clause analysis of the bill, continuing at clause 52, determination by commissioner as to special purpose. Ms. Murray, you'll be leading today.
Yes, Chair.
The minutes are not ready yet. They'll be ready for our next meeting, but you do have the summary sheet of the decisions made by the committee on clauses 1 to 51.
Chair, remember we had, is the word recommitted? Clause 47. Committee deferred clause 47 until the next meeting so that a written draft of the proposed amendment could be provided. It's on page 9 of the summary sheet.
Sure, while we await that, just to add as an action from previous meetings, just to notify the committee that we would have shared the ministry, that is, our comments in relation to some of the concerns that FID raised. So we have shared our comments with them, and so we're waiting now to have a sit-down with FID to go through the concerns that they would have raised and our response, and then we'll report back to the committee on that. We are hoping that a meeting will be scheduled between the end of this week and before the next meeting of the committee.
Thank you. And then with regards to clause 47, would that be for next meeting or for this one? Okay. Okay, copies are being made of the amendment. So we will proceed until we get those copies.
Chair, one other matter was raised last week in relation to the special purposes, journalism, literary and artistic purposes. So the SG had committed to reporting back to the committee, and I believe she's ready to do that.
Thank you, Chair. I hand over to Mr. Basco.
Good afternoon, Chair and members. So last week, and I don't know if members have copies of the bill with them, we're looking at clause 37, which concerned an exception to the data protection standards, among other things. the concern that was raised was in respect of clause 37(1)(a), which speaks to exemptions from the provisions specified in subsection 2 if the processing is undertaken with a view to the publication by any person of any journalistic, literary, or artistic material. Now, the concern that was raised, as we understood it last week, was that given the role of journalism, it was suggested that a separate treatment in terms of the exception be applied to that particular area as distinct from literary or artistic material. And so what we have found in the research is that no other jurisdiction appears to have treated them separately. The test that the courts have employed is the purpose. So when you're looking at journalistic, literary, or artistic material, the court's main concern has been with what was the purpose of the particular processing. So in one particular case, there was an artist who displayed a painting which had pictures of various public figures. They were in very lewd positions. It was just the head, but the bodies were exaggerated. And what the court found was, given the nature of the artistic piece, which was really a sort of satirical commentary on a particular political issue, that it quite properly fell within the exception. So what we are commending is that no change should be made to clause 37(1)(a), given the treatment, because all three of these matters do touch and concern an individual's right to impart information and to share and receive information. However, we are commending an amendment to clause 37(1)(b). Clause 37(1)(b) in its current form refers to freedom of expression in relation to the exercise of a data controller's processing powers. Now, internationally, from the European Convention perspective, the freedom of expression also includes the right to disseminate information. In our constitutional structure, freedom of expression is a separate right from the right to disseminate and share information. So we are suggesting that the clause 37(1)(b) be amended to reflect also a reference to the right to seek and distribute information in 13(3)(d) of the Constitution.
All right, so is it possible for you to read 37(b) with that amendment?
Okay. It would then read, in 37(b), the data controller reasonably believes that, having regard in particular to the special importance of the public interest in freedom of expression or the right to seek, receive, distribute, or disseminate information, opinions, and ideas through any media, publication would be in the public interest.
So members, I put clause 37 with the amendment to part B, as was read by Ms. Judith Grant. Okay. We could, Judith, if you could repeat it just for the two members that have come in. So members, there is an amendment to 37B.
Right, 37(1)(b).
Sorry, 37(1)(b).
So it would now read, the data controller reasonably believes that, having regard in particular to the special importance of the public interest in freedom of expression or the right to seek, receive, distribute, or disseminate information, opinions, and ideas through any media, publication would be in the public interest. And
I put clause 37 with the amendment to members. We accept clause 37 with amendments. Okay. We're still not ready. Oh, this is, all right. Printed copy of the amendment to clause 47 is being circulated. So, Ms. Murray, want you, or CPC, or Ms. Grant, 47.
Well, the amendment is pursuant to the discussion that was held last week, which included having a provision which would specify the minimum information to be included in the data protection impact assessment. So that's now captured in the new subsection 3. Then the other aspect of the discussion related to enabling the information commissioner to be able to specify which classes or kinds of data or data controllers would have to comply with the requirement under subsection 1 to submit a data impact assessment, data protection impact assessment. So that's captured in the new subsection 1, which the essence of the amendment is to insert the words unless otherwise specified in a notice under subsection 4. And then the new subsection 4 provides for the information commissioner to publish a notice in the Gazette or in any other manner appropriate to bring the matter to the attention of the public. The classes or kinds of data or data controllers who are required to comply with the requirement or who are not required to comply with the requirement to submit the data protection impact assessment. And then the new subsection 5 provides the factors that the information commissioner is to take into account in determining which classes of data or data controller are to comply with the requirement.
I put clause 47 with the amendments. There are no objections. We accept clause 47.
Good afternoon, Chair and members. So we are continuing at clause 52. We had one comment on clause 52 from the Press Association of Jamaica. They note that the section provides for the commissioner to determine whether data are being processed for special purposes. They expressed concern that such a critical determination about what is to them sensitive information is being made by a single individual. So the committee is asked to note that a determination by a commissioner or by the commissioner as to whether a journalist is processing data only for the purpose of journalism is not unusual. This is captured in both the UK Data Protection Act of 2018 as well as the South African Act. We note that the Commission will benefit from the examples of those, but importantly, that the machinery of the office, it is the machinery of the office that will assist the Commissioner in making the assessment, and as such, it will not be left to a single individual per se to attend to these matters. So the concern that a single individual will be responsible for doing this assessment, as raised by the Press Association of Jamaica, we think doesn't take into consideration that the Commissioner will have staff to assist in all his or her activities, or in the performance of his or her activities.
I just hope that a similar approach is taken for ministers. Apologies.
I put clause 52 to committee members. If there are no corrections or additions, we accept clause 52. Clause 53.
There were no comments on clause 53 from any of our stakeholders.
I put clause 53 to members. No objections. We accept clause 53. Clause 54, failure to comply with notice.
So on clause 54, there was one single comment from Hartmere Red Fatah, and their recommendation was that the fine, which is now set at $500,000, be increased. Members would note from our research the range of the fines as set by other jurisdictions. We did a calculation, I don't remember which month this year, but essentially the range goes from about 250,260 Jamaican dollars to up to 12.5. Which one? 23 million. Ooh, no, a little bit more. My apologies. Page 129, Ghana up to 23 million. My apologies. Right. So that's the range. 23 is at Antigua and Barbuda, right, on page 128 of our research findings. So there is a range, and we are suggesting to the committee that they could consider increasing the fine to $1 million.
I support that, Chair. What you don't want is particularly a large company just willfully disregarding the provision simply because the fine is so low. They just treat it as a business decision to do it. So I would support doubling the fine.
Through the chair, in our region, where does $1 million fall?
All right, so if we look at the findings, Antigua and Barbuda at EC $50,000 is 2.3 million for us. Bahamas at 2,000 Bahamian dollars is 250,000. Barbados at 15,000 Bajan dollars is 940. Going up to 6.2 million at 100,000 max. St. Lucia at 25,000 EC 1.157 Jamaican dollars. And in Trinidad and Tobago at 50,000 TT, $996,000 Jamaican, up to possibly, if there's a corporate body involved, 4.9 million. So the range, so those are, and that would have, in Trinidad, that's on summary conviction.
So is there a reason why, so in Trinidad, if a corporate body is involved, the fine may be higher? Is that correct?
Speaks to why they would have made a distinction between persons and corporate bodies, but our research shows that they, along with Antigua, are the only persons who make a distinction between the individual and the body corporate. But we'll just remind members that we do have a provision, and we're going to get to it, for fines against corporate bodies, which is 10% of their annual revenue, which of course there is some concern around that. So there is a provision in relation to fines of corporate bodies a little later in the bill.
So sorry, Ms. Murray, you're saying this just relates to an individual or a company as well?
Well, this would be an individual, as is now, right? But there is a general provision at Clause 70, thank you, regarding the liability of body corporate directors, etc.
Okay, I put clause 54 to members failure to comply with notice with an amendment to increase the fine from $500,000 to $1 million. There are no objections. We accept clause.
Let me just to be clear, you're saying that for 54, and I think it's important for the Hansard even to, for us, for our records to understand before we go to 55. A person in 54 is not a body corporate. A person in 54 is not relating to a body corporate. That's what you're saying? But that's not what we just said, isn't it? Unless maybe I'm not understanding, because what I heard a while ago. So clarify for me. What I heard you say a while ago is that this is speaking to an individual in response to one of the members. Now, clarify for me if that's what was meant, because the interpretation, and I lean on SG and other advice, interpretation of the word person in law would include the body corporate. So is that what was? Yeah. So guide us, please.
You're correct. A person, I think what I had in my mind when I responded was individual as opposed to a person, that the language was an individual. But you're correct. A person is defined in law as both a natural person and a legal person. And so if given its definition per our Interpretation Act, then that it would be applicable to both an individual, a natural person, and a legal person. This provision is in relation to one thing, and that is the failure to comply with an enforcement notice. The clause I referred to at 70, which is wide and reads where a body corporate commits an offense under this act, is broader than this.
That was my understanding. So glad for the clarification. So how does that sit then with the questions that were raised before in terms of the...
So it really would depend on where and how the prosecution takes place. If it is that they're charged on clause 54, which would give that specific, or you're going to do also a 70, take it from at 70, in which case the fines would be different. And you'll note that in determining the quantum of fines at 70, the court will have to take other things into consideration.
What we could do to make the members satisfied is come back to this when we analyze 70 so that we can see exactly where it stands, because it seems as though there are still a number of concerns about this particular clause. Unless you want to jump to 70 and let us discuss it in the context.
Well, I'm just concerned about the possibility of duplicity, if that's the right way to say it. But I'll leave it. Let's move forward, and we'll have time to look at it.
Except that the issue that is raised would be applicable to all the offences that are single offences created, because there's an approach that could be taken. The approach that could have been taken is to say that if there's a contravention, then there's a general offence principle clause, for example, and then you set an amount, and that would be applicable to any breach of the legislation. But you'll find throughout this piece of legislation that what would have been done was that there are offences created at different points, and specific fines and or term of imprisonment attached to that offense, and then there's this general one with respect to body corporate. So we'd have to look at it, or the committee would have to look at it, all the offenses, because this isn't the first offense, as against 70.
Hold on. So what I heard said a while ago again, which is why I'm saying we need to look on it, is, and again, correct me if I'm wrong, that it would determine what section the person is charged under. And now the concern I would have is, if I commit an enforcement notice, Chairman, and you have the ability to charge me under 70 as a body corporate, I would have a difficulty, because it means then that we will be promulgating a legislation that has a certain amount of uncertainty. But guide me, SG.
No, I think the way it would work, I think it is clear now. I mean, I heard CPC saying, well, if there needs to be any further clarity, we could always put clarity in. But as far as I see it, if I'm looking at, say, the offense, as an example, the offense in 54, and how it would apply to a body corporate. So if you went before the judge and you are a company, and the judge has found that the company has breached clause 54, the judge then has the judge is then obliged to consider, when imposing the penalty, what clause 70 says. And what clause 70 says in relation to a body corporate, that whatever fine that will be imposed must not exceed 10% of the gross annual income. So remember, you already have a maximum here in clause 54. So the court would just then take into account whether or not the penalty the court wants to impose would exceed 10% of the gross annual income of that body corporate. Further, the court should then take into account, there are some guidelines set out in 70 sub 2 that the court should also take into account when deciding what's the appropriate fine to impose. So I don't think that there is any inconsistency. I think it is just giving further guidance to the court. And to go a little further, if there are general sentencing guidelines across the board, no matter what a law says, the court then always has to take into account those general sentencing guidelines. I just see 70 as one form of a sentencing guideline that is being given to the judge. But again, I mean, when we get there too, we can always look to see if we want to make it any clearer, although I don't see that there is any need, but we can always, again, go through it and reconsider to see if any words need to be added to make it very clear for the avoidance of doubt.
I just ask a question. Let's take a non-profit like a club that is in breach, is it who would be the person who would be liable to pay a fine in a scenario like that? Are they considered a body corporate?
Yes, I don't think that they would be considered a body corporate. So I think what you would probably do is go after the individual.
And who would that individual be?
Okay, so guidance, when it comes on to a body corporate, for instance, what the Interpretation Act will say is if you're imposing a custodial sentence, well, clearly a body corporate can't be sent to prison. Normally, that custodial sentence can be imposed on any director or secretary to the company. When it comes on to, say, an NGO, an entity that doesn't fall under the rubric of body corporate, I think it would be left to the persons who are prosecuting to determine who they think is the appropriate person within that entity that would have failed to comply with whatever it is they're supposed to comply with.
Okay. No, what I'm asking, if let's take a political party for example, we're not a body corporate, a sports club, a church. Who you go after? The pastor, the head of the church. How do you make a determination about who would be liable for the fine? That's what I'm trying to find out. And the question would be, even though there may be a designated officer who would have responsibility for dealing with the matters, is it that person or the person who's the head of the corporation, of the entity?
My understanding that it determines the legal structure of the entity. So you can see there are many persons say that they're charities, but they're not registered charities. It's not an incorporated company that has a charitable number, but they represent as a charity because of the function of their business or organization. So it would determine, it would be dependent on the legal structure of it. Some churches are just groups of persons that come together and say they're churches. In that regard, whoever is the head, who's in charge, would be the one who I'm sure the prosecution will go after. But if it is a legal structure, which is incorporated, then at that point in time, you would have documents that would be able to guide you as to who and how to approach that kind of prosecution.
Just to point out as well, so when I was explaining that the issue with the body corporate, if the entity is not a body corporate, Section 70 won't apply. But the Interpretation Act defines person to include a club, a society. So technically, when the Act says a person who fails to comply, it could be a club, it could be a society. It's just that if they don't fall within the rubric of a body corporate, then Section 70 wouldn't apply.
I'm going to take on board the members' suggestion to go to clause 70 in light of the discussion we're having on fines, so we could take both 54 and 70.
So, members, while there were several stakeholders who commented on this particular clause, the concerned Jamaica Bankers Association, Jamaica Computer Society, FLO, yes. Essentially, the concern was around the 10% and the fact that they thought it exorbitant. So that was a single concern. And so there were recommendations around setting a precise sum as opposed to, and or maybe I suppose less, something less than 10%. So members are directed to the comments that the 10% represents really a maximum. The court would assess based on the guidance provided in the clause what it would apply as a fine. The 10% is a maximum.
I don't recommend changing it. I think we should keep it. You need to have strong deterrence. And I think we have seen in other jurisdictions in the EU where they have imposed significant fines on very large players. And I think if you don't have something which people will take seriously, they'll just have absolutely no regard for the law. So I don't believe we should change this. If people comply, they don't have anything to worry about.
Is the, just asking a question, Chair, so the 10%, is it of gross income everywhere else? And is there, no, I mean, because gross income, you can make very little money although you gross in, because your expenses are so exorbitant that your profit is really small. So that's one of the points that I wanted to raise. I forget the other one now. It was two.
And that point is taken, remember, because interestingly, if you look at the research finding in relation to the GDPR, they have set it at 10 million, or in the case of an undertaking, up to 2% of total worldwide annual turnover. Or whichever is higher. So the focus here is on the worldwide annual turnover. To your point, that are we thinking about the organization that is just local here, locally established, or we're talking about a global, a conglomerate, for example, which has its branches and so on established in other jurisdictions.
And just for interest, you're going to be depending on how would you, the tax records is what you're looking at? Oh. Well, I can understand that.
It would have to be because it speaks about certainly the GDPR, not ours, but a financial year. The preceding financial year's revenue, turnover.
Never use net profit because if you go net profit, nobody would ever declare a profit. But it's a maximum fine, and if you look at the clause, it says you take into consideration the impact that the breach would have on consumers. So it doesn't mean it's automatic that it would be the 10%. It could be 1, it could be 2. But I really feel strongly that if you're going to get compliance, there has to be a deterrent. And we see it at other levels in other laws that if you don't have something which impacts people in a meaningful way, they're just going to disregard it.
So, Ms. Murray, I go back to my question, though. When I look at 54, clause 54 versus 70, it's clear that in 70 it says a body corporate. But 54 says a person. Can you explain again?
A person is defined, Minister, Chairman, as including any corporation, either aggregate or sole, any club, society, association, or other body of one or more persons. And by that include, it means both the person as an individual, a natural person, and by the explanation, a person who is a legal person, i.e. a company, a body corporate, an association, and so on. So that is what person, a club, a society, that is what person means. So the individual, natural person, and or persons who are incorporated and or if not incorporated, certainly fall within the category of a club, a society, or an association, or a body of any other persons.
So when do you decide which of these to use then? clause 54 or 70? When would a court decide, and under what situation would they decide to use clause 54 versus clause 70?
So how them find Google?
How them the Google in the EU?
Google Spain got lick and
and them the Google, them the worldwide.
Yeah.
And the EU them the worldwide too.
So why we don't?
Sorry, Chair. As I understand it, you're asking when would a court decide whether to use the fine in 54 as opposed to what's in 70? No, it's not a choice. When imposing any fine, 54 or anywhere, the court has to consider what is in clause 70. So once you're a body corporate, the court must always take into account what is in clause 70.
So you could be fined under both?
Question.
No, so it's not a separate fine. It's not a separate fine. So again, take clause 54. Yeah, but it's not necessary. So a person would have failed to comply with an enforcement notice. Let's say Aldred and Associates, a body corporate, has failed to comply with an enforcement notice. The court is going to first look to see that the fine here that can be imposed is one not exceeding $500,000. However, the court is then going to take into account Aldred and Associates is a body corporate. So the court is then going to say, fine, I can look to see my starting point is nothing more than $500,000. However, I now need to consider, is that maximum, and remember now the court doesn't always have to go to the maximum, but is the fine that I'm thinking of, does it exceed 10% of the annual gross income, which is what's in 70 sub 1. The court should go further. The court should then say, well, this entity committed an offense. I should look to see all the things that are listed in A, B, C, D, and E of sub 2 as well. So it is a number of things. The court will have to now go through a sort of a process in determining at the end of the day what is the appropriate fine. But you would start, the court will always start with whatever is in, so clause 54, I'm looking at 500,000, that would be the starting point, and then the court would then now take into account all the factors in clause 70.
I put clause 54.
Hold on a second, sir. 1 minute. Question. You use the term annual gross income of that corporate body. However, the GDPR uses a more expansive term. Is there a reason why you have not been as expansive as the GDPR?
Remember, we actually didn't look at the GDPR in relation to this one. Jurisdiction we looked to in relation to this one was actually Trinidad and Tobago. Yes, on 70.
So which one had this global?
So the one that has the global is the annual worldwide turnover is the GDPR, but that wasn't what we used as instructing our minds in relation to this, but to our clause 70. What we would have looked at in terms of a jurisdiction is Trinidad and Tobago's provision, which didn't use the language of an annual turnover. I think my response was in relation to the question that was raised by Member Scott, that we might want to look wider, and I was saying that she does have a point in that regard because the GDPR looked at it in a particular way. So we would have been a little bit more restrictive in terms of the entity established here and what their revenues are as reported here. But taking the point that there is an example of someone or a jurisdiction, or a region, EU, that would have looked at it slightly different and would have gone broader than just one single, what the entity as established in the EU.
So there's this case, Google Spain SL. I don't know if you know it, right to be forgotten, where even though the matter was focused on Google Spain, Google Inc. was a part of the whole conversation because SL was a subsidiary of Google. The reason why I raised it is, if it is that you're trying to use deterrence, and you have a company which is a large multinational corporation, which has a subsidiary in Jamaica, and we know that we have bilateral agreements on double taxation and so forth. So the ability to know how much a country is making, which is an international corporation, is pretty easy based on those bilateral agreements, because they would have had to submit information in order not to be double taxed. Why is it that we're being restrictive with these multinational corporations and not extend the liability beyond just the local subsidiary? Because the impact on the data subject would not just be local in many cases, but will have international implications. And if it is that we really want deterrence, in light of all the treaty frameworks and bilateral tools that we would have in terms of taxation and so forth, which means that we can know how much money they're making if they are a subsidiary and they're a reputable company, why be so restrictive?
And we're saying that we're open to the issue that has been raised and the concerns raised by the committee. And if the committee is minded to add that language, we certainly have no objection. The point I was making was that we would have looked at one jurisdiction who did it in a particular way. But in light of the comments that would have been made, we know that the GDPR does a much more broad, or has a broader remit in terms of the applicability of the fine, and so that and was shared, so that if the members are minded to go in that direction, then the members would know that there is an example of regulations that have that wide remit.
Is the suggestion practical in our circumstances, and if so, what do you recommend? I'm not concerned about what Europe is doing as it relates to what we should do, but it's an example. But is it practical, given the precedents that you've seen and what you would have analyzed? Do you think it is practical to adopt that approach in our circumstances? And if so, what's the best formulation?
It might be, because if you think about for example, Standard 8, which speaks about the ability of a data controller to transfer. And in that discussion, we would have shared concerns from stakeholders that said, to the effect that companies that have without using examples, or financial institutions or telcos, for example, that have outfits in other jurisdictions and would want to transfer the data to their other outfits in these jurisdictions. And we would have considered that would have been and should be allowed in those circumstances, because while it's all company-wide, it's one company and still within the group of companies. Then it means that if it is that there is a breach of the legislation by virtue of that transfer, you now move from this jurisdiction to another jurisdiction, and that breach is happening effectively outside of Jamaica, but still by an organization established here, then the gravity of the breach could be one that very well requires you to look at the turnover for the conglomerate or the group, as opposed to the single entity that is established in Jamaica called XYZ Jamaica Limited.
Let me just say, this has enormous implications, okay? Way beyond this legislation. So, I think it is something, Chairman, that we should tread very carefully on. When you start talking about creating nexus between companies globally, you're talking about not just deterrence in terms of any possible breach, but you're talking about other kinds of deterrence that we don't want. So I think we need to be very careful. I'm not against it, because the concept is something which is logical in terms of wanting persons to realize the potential impact of an action as a consequence. But we have to think very carefully on that, which is why I asked you about the practical application of such a thing in our context, not Europe, but in our context here. How does that fit with our legislation, and even the legislation that is referred to in terms of double taxation? How does that fit for Jamaica?
Bearing in mind too the comment that was made about companies that don't report a profit within the jurisdiction, and the question would be, if they're brought before the courts under this legislation, what exactly would you be applying the fine against? So in a case like that, you might want to be able to reach the group and look at the group financials as opposed to the single company that is established here.
So members, all right, let us go back to clause 54. I put clause 54 to the members with the amendment to increase the fine from $500,000 to $1 million.
Well, we were considering how Section 70 could be reworded to take into account the concerns, and the discussion that we were having was making it not targeted at bodies corporate per se, but at any person who derives a profit from the data processing. That would be a factor to be taken into account in determining the level of the fine for any offense, regardless of what the specific penalty is stated, for example, in 54 for the offense. So once a profit is derived, then you would go to 70 and take into account the level of the profit in determining the quantum of the fine. So it could be redrafted.
But I don't know that I would go to profits, though. Profits can be manipulated to be whatever you want it to be. I don't know that I'd use that as a criteria.
Well, we would still talk about the annual gross income in determining it. What would send you to 70 is the fact that you derived a profit from data processing. So in determining the level of the fine, they would look at the annual gross income of the person and determine the level of the fine from that.
Member, use the other mic, please.
No, I'm saying that mention was made about companies that do not report a profit. How would you determine their annual income?
We don't want to use profit as a criteria. We want to use the revenues of the company or the gross income. Yeah.
Chair, here's my dilemma. So this law allows or envisages that a company may be transferring my data across, as you said earlier, particular geographic spaces. Data centers are all over the world. I know of a huge data center in California that processes some Jamaican data. We know of others, other places. So a company has a subsidiary here in Jamaica that processes my data, transfers it to another country. My data is compromised. The data commissioner takes this company to court, the local subsidiary. The local subsidiary is a shell. The multinational corporation is highly profitable. The victims of that data breach, based on how it is written here, have very little recourse because the law does not allow them to seek redress, as Europe allows, from the parent company, who would have ultimately benefited from the use of the data and may have been culpable in the compromising of said data. Additionally, other countries have different data protection criteria other than what we're doing here. And these companies that work in Jamaica also have businesses in those countries who may be interested in analyzing our data while it is being transferred. So if it is that we are not looking at the parent companies and the fact that they are the ultimate profit makers of the use of the data and may have caused the breach, then how do we give recourse to the data subject in such a case? That's the question. That's the question I want answered.
In the same way that we have provisions for holding bodies corporate liable for things that individuals may do in their name, is it too far stretched to hold parent companies liable? And how are we protecting our population if we don't?
Because I'm not au fait with a lot of this because I'm not a lawyer. But if it is that companies benefit from the transfer of data and companies benefit from double taxation mechanisms within our laws and treaties and bilateral agreements, and they're benefiting from the use of our data, why is it that they should be insulated from the consequences of misusing such data?
I believe that the observations made by Senator Morgan are worthy, very deserving of some analysis and consideration. I do recall that Digicel made a very extensive presentation which might not have supported his point. I can't recall, frankly, but I do think we ought to think about it a little bit more. Because the example which he gave really of the company being a shell here and the data being mined elsewhere is something that has stimulated my mind as to the possibilities. And I do think with this piece of legislation, it is better that we be careful rather than just trying to get it done.
Okay, and when careful meaning what side of it? In the total worldwide or just leave it as is?
I feel that we should probably get some more information as to, I am tending now, having heard all the arguments, to more the worldwide, especially since the information is accessible. But I would like some more advice on it.
Chair, just the subsection 4 of 70 is unusual in that it's making the members of the body corporate liable in like manner to officers. And the members of a wholly owned subsidiary would be the parent. The member would be the parent company. And so if it is managing the affairs of the subsidiary here, then subsection 3 applies, and the offense committed by the subsidiary, if it can be proved to have been committed with the consent or connivance or to be attributable to any neglect on the part of the member, then it would be liable in like manner to the subsidiary. It's unusual. I've never seen that provision before, subsection 4. And of course, 10% of gross income can be a massive fine for any substantial business. I mean, way more than any fines that are normally found in our statutes in terms of quantity.
Not exceeded,
I know, but it's as an upper limit. Fines are typically not exceeding, but as an upper limit is a very, very substantial fine.
Member,
could be.
Through the chair, member, in my mind, if it is that a corporation, there's currently a corporation that operates within our society that has data on 1.5 million Jamaicans. They have biographic data. Some of them have your iris, all of those things, all of the varying data, identification data. That company is using that data currently to sell ads to corporations in Jamaica and outside of Jamaica, making significant profits on those ads. When I read this clause, when I read the clause 70, the one that we're discussing, those are the companies, and I stand to be corrected if I'm wrong, but those are the companies that I see may be most targeted in that regard, companies that have a significant amount of data on our subjects, Jamaicans, and based on the use of that significant amount of data, may be turning a significant profit based on that data. So I would hope it's a deterrent so that they do not fall afoul of it and have to pay it. But if it is that it's not a deterrence, based on the significant damage that could come from a breach of 1.5 million persons, all their information essentially. I'm referring to Facebook. When you sign up to Facebook, you do give them, and then they have this new thing now where you can sign up with your biometrics. So they have that information. What if 1.5 million Jamaicans' information is breached by Facebook? How would Jamaicans get some? I don't know if you understand where I'm coming from.
Would the Jamaican courts have jurisdiction over Facebook? I don't know. I mean, it's an important question, and I don't know if the legislation addresses that or not.
If they have a subsidiary here, right?
No, they don't. Facebook?
I said if.
Oh yeah, but they don't. Google doesn't either. None of those. The other point on subsection 4, though, if the example given by the member of a relatively small shellish company operating here, owned by a large multinational, if the offence is committed by the company here, the fine would be a function presumably of its gross revenue rather than that of the parents, and the parent's liability and its operations.
So That's why I think members are saying this deserves a little bit
Right.
more research, especially as it relates to whether or not we maintain what we have or we broaden it to total worldwide annual turnover.
And whether we can give our citizens a cause of action that is against entities that are not physically present here, but whose products or services are used by Jamaicans, are accessible by Jamaicans. You know, and if their data is breached, that 1.5 million or whatever the number is, what recourse do Jamaicans have under Jamaican law? Or do they, you know, do they have to rely on the law of wherever that large entity is incorporated, or and so on? It'd be good if Jamaican law gave them, this act gave them some recourse, which they could enforce, if necessary, overseas.
But that's not captured here, though, at all. Yeah, yeah. All right. On clause 70, what I hear from members, and I agree with, is that we should consider widening the fines to the total worldwide annual income. But before we can do that, they'd like to get some more research done on it. And I would recommend as well that you speak to TAJ, because I know recently there were changes that allowed our tax authority to look at worldwide income, you know? And so we will defer clause 70 until our next sitting, pending more research on the implication of widening this to total worldwide annual income. In the meantime, I go back to clause 54 and put clause 54 with the amendment to change the fine from not exceeding $500,000 to not exceeding $1 million. If there are no objections, we accept clause 54. We move on to clause 55, rights of appeal.
On clause 55, we had a comment from, well, we have 4 comments. One from the National Consumers League. They recommend that the Act should provide a first appeal at the administrative level before seeking intervention at the parish courts. The Broadcasting Commission, a provision for members of the public to appeal against ruling or complaints about or other aspects of the work of the Information Commissioner. Flo recommended that a provision recommended that a tribunal be established to hear appeals, and that a provision be included in the Act that while an act of the Commissioner is being appealed, the status quo be maintained and the Commissioner's actions are stayed pending the outcome of the appeal. And then we have one comment from the Press Association of Jamaica. And they looked at it in the context of Clause 37, which provides for the Commissioner to determine under Section 52 whether data is being processed for the special purposes. They know that once a determination is made, the only appeal process is by way of court proceedings per Section 55, which will likely be expensive and time-consuming. Concern here being then that their recourse is to the courts. We did some research to see how other jurisdictions would have treated with that, and members would see that for the most part, appeals are to the court. Specifically with respect to the National Consumer League of Jamaica's recommendation, it is the Ministry's view that it would be inappropriate to have the Commissioner deliberate on actions that he or she has taken decisions and actions of the commissioner ought properly to be considered by a separate body, and that body would be the appeal tribunal that is established pursuant to clause 72 of the bill. In relation to the Broadcasting Commission's recommendation that other aspects of the work of the Information Commissioner be subject to appeal, we note that appeals ought properly to be from decisions or determinations made by the commissioner, as is the case with other regulators, and not complaints about other aspects of the work. A person aggrieved by any decision of the commissioner other than decisions regarding information enforcement and assessment notice may appeal to the tribunal. With respect to Flo's comment and the PAJ's recommendation, respectively, the committee is asked to note that while the research conducted appears to suggest that more countries allow for appeals to a court than an appeal tribunal, consideration could be given to allowing appeals of all the decisions of the commissioner to go to the appeals tribunal. We're just reminding here that essentially there are some decisions in relation to the issuing of an information enforcement and assessment notice. The appeals for those decisions go to a court, but for any other decision of the commissioner, it would go to the appeal tribunal established under clause 72. So what we're saying here is that the committee can consider having all matters go to an appeal tribunal, since the concern is that going to a court might be time consuming and costly. So that's for consideration. The ministry doesn't support the recommendation of Flo that the decisions of the commissioner be stayed pending an appeal. The committee is asked to note, for example, that decisions of the OUR, the Office of Utilities Regulation, and the Spectrum Management Authority under the Telecommunications Act are not automatically affected by the appeal proceedings. Decisions to stay are made by regulators where they consider the circumstances of any appeal to be exceptionally so as to justify staying the decision to which the appeal relates. And we would have referred you to section 62 subsection 3 of the Telecoms Act as an example of one instance in which when the regulator makes a decision, the decisions are not stayed while the appeal process is in train.
Chairman, if I may, I would like to understand from the team the reason why, looking at 72, looking at section 72. No, because in the ministry's response, it references section 72 from 72, yes. Because at 55, it says that the enforcement notice and assessment notice, maybe one may appeal to the court against the notice. And 72 explicitly forbids those notices from going to the appeal tribunal. So I wanted to understand the reason behind that.
What page is 7? On page
83.
72?
72.
So assessment, enforcement notices, and the other one is enforcement, information enforcement and assessment notices can affect, once issued, can affect the business of the data controller. And we were of the view that in those instances, if a data controller wants to challenge that, they might feel that a court, the finality of a court's decision might be a little bit more than the decision of an appeal tribunal. So that was our thinking in terms of making a separation between those types of decisions made by the commissioner vis-a-vis something else. And saying to essentially to the data controller that for these matters, your appeal to the court could essentially give, have the matter heard heard in proceedings that will give you some finality. Because, I mean, anything on appeal can then go to court after that anyway. So that was the thinking. But we're saying that since the stakeholders have raised concerns about the process and the timing and the cost, then if it is that the stakeholders have no objection themselves, it seems, from their comments, to having all the matters dealt with at the appeal tribunal level, not excluding, of course, their right to go to the court after that, then the committee could consider, which would make an amendment to 72.
That really depends on whether that appeal tribunal is going to be constituted and available and accessible, because some of them are not. Yeah. So I would be hesitant to remove where you have orders being made which affect the business of companies, to give them recourse to a tribunal which is not going to be a permanent staffed tribunal, but is an ad hoc tribunal in the sense that it's only constituted when there's an appeal and so on. And given our experience with these bodies, I would be slow to change what's here. But one question I had for you, though, in what you were reading in relation to, I think it was either the OUR or the Spectrum Management Authority, it was to do with stays. You were saying there's no automatic stay. But is there provision for the grant of a stay? But is there in this?
No,
perhaps we should add it then?
So we could consider language along the lines in the Telecoms Act, which empowers, but this would be the commissioner making a decision to stay his own determinations and our decisions. Essentially, but they would look at the matter itself and then determine whether or not this is something in the circumstances that they should stay their own decision, as opposed to there being an automatic stay.
And they do that in the context of an appeal to another body?
We'll check on that. I don't think so.
And since the court would be, its jurisdiction here would arise under the statute. If the statute doesn't give the power to grant a stay, does the question arise whether it has that power? Wouldn't it be best to actually expressly provide for it, rather than leave that to some judge to interpret?
So, members, we have confirmed that it is actually the regulators under the Telecoms Act that determine whether there are circumstances sufficient that are exceptional and that would merit them staying their own decision. That's the language.
Not in the context of an appeal. It is in the context of an appeal. From who to who?
So it would be the licensee in this case who is appealing to the tribunal, the Telecoms Tribunal established under the Telecoms Act.
From a decision of?
A decision of the office or the authority, as the case might be.
So the appeal tribunal has the power to grant the stay. Who has the power to grant the stay?
Regulator. So essentially what the provision says is that there is no ability to stay, and the only persons who can consider is the regulator themselves.
But in the context of an appeal to the court, I mean, courts typically have power to grant interlocutory remedies.
Sorry. Members, sorry, what is it, Ms. Murray, can you just summarize what it is that we're trying to do with clause 55?
No, I think, well, the only thing in our mind that is up for consideration in terms of an amendment is whether or not all decisions of the commissioner ought to go to a tribunal on appeal vis-a-vis what we have now, which is the enforcement, assessment, and information notices going to the court, and then other matters going to the tribunal. That's the question. Well, that's the sole recommendation, certainly from the ministry, that is on the table. But I think in what the members seem to be trying to clarify is the comment or recommendation made by Flo that while the appeal process, appeal to the tribunal, is in train, then the decision of the commissioner should be stayed. And the ministry's position would be that we would not support that, and we would have used what obtains under the Telecommunications Act as an example of an instance in which, while there is an appeal in process, there is no stay of the decision of the regulators pending that appeal process.
Sure.
The idea here being that if the commissioner and or the regulator under the Telecoms Act in this case gives a directive to a business or a licensee or to a data controller, they must give effect to it, because the delay could impact data subjects and their rights under the legislation if a stay is allowed.
But supposing the commissioner is acting unlawfully, capriciously, in breach of the rules of natural justice, ultra vires, whatever it may be.
Judicial review?
Yeah, so what, the power to grant a stay must be there.
Yeah, but wouldn't the court...
If there's an appeal, you can't go by... If the right of appeal is given under the statute, then how you can't have judicial review unless you've exhausted the right of appeal.
Members?
Miss Murray, can you explain to me slowly so I can understand? What's the hierarchy of authority based on this legislation going up? Is it the commissioner, the tribunal, and if the company or whoever that issued it goes to, and the tribunal is not satisfactory, then they can go to the courts?
Essentially, for some matters, the commissioner will make so there's a complaint, let's say a complaint from a data subject, with respect to compliance or non-compliance by a data controller. That concern or complaint would go to the commissioner. The commissioner, under the legislation, would be required to do his or her investigations and make a decision and issue those instructions or directives to the data controller for correction. If the data controller has an issue with that or takes issue with the decision, then the process is an appeal to the appeals tribunal established under Clause 72. However, if it is a matter in relation to an assessment notice, an information notice, or an enforcement notice, that is taken to the courts directly and not the tribunal. So that's the carve out there. Every other matter goes to an appeal tribunal.
But for everything that is within
And
the
then
law.
after the appeal tribunal, the fact is that at the end of the day, if the parties aren't satisfied, then they can always take that matter to court.
That's what I was
I
asking.
mean, is there a right of an appeal? Is there a right of appeal from the appeal tribunal to the court?
You don't have to provide for that because judicial review
Yes,
would
but
always
a
apply.
judicial review is a different type of review.
It's true.
I mean, a
They don't go
judicial
into
review
facts,
is
they
looking
just go
at
into the process.
not the substantive merits
No,
of the
not
matter,
the-
whereas
the
an appeal
process.
is. So I was just asking if from a substantive appeal point of view, it ends at the appeal tribunal unless they've violated some procedure or misinterpreted the law under which they operate or something. So, okay. But in the same way that in judicial review, the CPR, I believe, provides the court with power to stay the proceedings. Yeah. If you're not, in the case of the enforcement notice and the other two forms of notice where there isn't an appeal to the appeal tribunal, but there's an appeal to the court, you're not going by way of judicial review. Where would the power to grant a stay come from if the statute doesn't give it?
So you're saying if the person is choosing to appeal to the court,
Yeah, and
the court would have that power.
From what source? Inherently? When it's
No.
exercising a statutory jurisdiction?
From the CPR, they would have. Let me find it. But the court has that power.
Check it for me, please, because in the case of judicial review, that power is expressly provided in the CPR.
Chair, I think we're going to take that issue raised by Member Golding and consider that. So I don't know.
All right. While the research on that question for clause 55 is being done, we will take clause 56.
So, Chair, just one question on the 5. I just wanted to be clear which direction the committee is going in relation to the recommendation, whether we're keeping some things on the track of straight to court to.
What is it she was looking at?
Okay. All right.
Or we just wait for SG. Yeah. So
only insofar, Chair, that perhaps the response to that question may impact on how we treat with 56. I think maybe that may just be the concern for Ms. Wakim. But I noticed that the Solicitor General stepped out, but in relation to the question I asked earlier about the recourse to the court vis-a-vis the recourse to the appeals tribunal, is there anything, I don't know if it's an unusual provision for there to be an option, so one can choose to either go to the court or can go to the appeals tribunal. Is that unusual in statute? I don't know if in your experience you've come across anything like that. Maybe CPC?
Unusually, yeah. Usually it's a graduated scheme, and from my recollection of how courts usually treat it, where there's an alternative, they usually require you to exhaust other available options before you get to the court. Yeah. Sorry, while we deliberate, Ms. Murray, could you just remind me, is there a cost associated with going before the appeals tribunal?
No, except those costs that would be related to each party's counsel, yes. What we would have to make provision for, however, which is more administrative as opposed to something that we'd find in the legislation, is, where is it in there? The payments of the appeal, the tribunal itself in respect to their compensation for the work that they're doing. But essentially what would typically happen is that where counsel is engaged, then each party who is a party to that appeal would pay their own.
So if you're not satisfied with the decision of the tribunal, you can just go straight to court. That's correct, right?
No.
Is that what it is?
As it is now, that's what the question that Member Gulu was saying. As it is,
that is what we're trying to clarify based on the question that was raised. I think that's why Member Golding had asked if there was a right of appeal in the legislation specifically to treat with that, because I think what we were saying here is that you can appeal on a judicial review of, but we're trying, I think that's the issue that we're trying to clarify.
I wouldn't.
Chair, okay, so we have clause 55. I think we had determined that we're going to hold on that until we have some clarity from the SG. And 56 is related. So if the committee wishes me to move to 57. There are no comments on 56, but 56 is related to 55. So
we can go to 57 then. Power powers of entry and inspection, third schedule.
Okay, so clause 57 treats with the power of entry and inspection and is related to the third schedule. We have, or the committee would have received 3 comments on this clause from the NIDS project, Jamaica Computer Society, and Lawyers Christian Fellowship. All right, for what it's worth, even though we don't have a National Identification and Registration Act or bill, so the concern by NIDS, so it's clause 57 and the third schedule, right? So the concern by NIDS at the time was that the powers of inspection under warrant obtained by the parish court judge appeared to them to be in contravention of the NERA. And I'm still raising the issue because I know where we are with that, right? Which requires that a court order from the Supreme Court be obtained in order to grant access to the database held by that authority, or that would have been held by that authority. So they recommended that a limiting provision could be incorporated into clause 57, which would essentially read, a warrant issued under this schedule shall not authorize the inspection or examination of any information which would otherwise require a specific court order in order to be accessed. The concern by NIDS members may recall was that essentially the commissioner should be required to obtain a warrant from the Supreme Court in order to be able to enter the premises of the authority and access its database or any of its properties. The provision would serve to protect the confidentiality of identity and other information contained in the National Civil and Identification databases, was their contention. They also proposed that the third schedule could require that the Information Commissioner provide details of what is to be searched and seized where applicable, and justification provided for such search and seizure. With respect to the Jamaica Computer Society, they recommended that orders under the bill be sought from a Supreme Court judge and not a parish judge, as is the case for similar warrant. My apologies. As is the case for similar warrant requests under the Interception of Communications Act. Lawyers Christian Fellowship had concerns that the power of the commissioner to enter, search, and seize was wide. They noted that the effect of the provision is that in order to protect privacy of our data, we are empowering the commissioner to breach the privacy of homes and offices. They recommended that applications for a warrant should be made to the Supreme Court, and that the reference to parish court would be inconsistent too. They raised that with the then NIDS legislation. They also recommended that no warrant be given unless the commissioner can show, among other things, that notice has been given to the alleged wrongdoer of the breach. So essentially our comments in relation to the NIDS, JCS, Lawyers Christian Fellowship, we noted that the recommendation from the NIDS that a court order be obtained by the commissioner would not have been feasible under their scheme in any event, because only those persons who were engaged in national security, crime prevention or detection, public health, or public emergency, or an investigation under POCA could actually obtain a warrant from the Supreme Court for access to the database at NERA. So our contention here is that their recommendation wouldn't, for the commissioner to go to the Supreme Court to obtain a warrant to search and enter and seize would not have been feasible under their legislation in any event, because the commissioner wouldn't fall within any of these broad categories of national security, crime prevention, public health, or public emergency. So that was one point. With respect to the use of a parish judge to issue a warrant in the data protection bill, and that was a concern that was raised by both NIDS, the Jamaica Computer Society, and Lawyers Christian Fellowship, we were recommending to the committee that the reference to a parish judge could be replaced with a judge in chambers of the Supreme Court.
It's quite common for where the statute provides powers of search and so on for the application to be made to a parish judge. It's not an unusual thing. There are many examples of that. I don't know why the parish judge was chosen in this instance, other than perhaps because that's what the normal provision is. Why was this provision put in a schedule? Is there any reason? Is it just because it was a bit extensive, or it's not like it's amendable or anything more easily than?
We had 3 stakeholders that raised it as a concern. When we're saying to the committee, if they're minded, then they could replace the parish judge with a judge in the Supreme Court. With respect to the Lawyers Christian Fellowship's recommendation that no warrant be issued unless the commissioner can show, among other things, that the notice has been given to the alleged wrongdoer of the breach, we want to draw the committee's attention to paragraph 1 and subparagraph 3 of the 3rd schedule, which provides that a judge may grant a warrant where he or she is satisfied that the data controller has failed to comply with a requirement imposed by a notice. So he or she, or it, data controller, would have been issued a notice, and therefore would have been his or her or its wrongdoing would have been brought to its attention. So we didn't recommend any changes in relation to that. So the single recommendation for possible change that the ministry is proposing is the committee to give consideration to whether or not warrants should be obtained from a parish judge as opposed to a Supreme Court judge.
Chairman, if I may, on page 105, the 3rd schedule, section 2.3. (2.3b). If the person who occupies the premises in respect of which a warrant is issued under the schedule is B, not present when the warrant is executed, a copy of the warrant shall be left in a prominent place on the premises. Am I understanding correctly that if an office is closed, then the person who's executing the warrant can let himself in if no one is there? No? Can you just explain to me? No, so how we read 3, 2, well, 3 says 3. B, if the person who occupies the premises is not present, then the notice or a copy of the warrant must be left. If the occupant is not present on the premises, no one is on the premises, does the person who's executing a warrant, can that person still have access to because that is my understanding. So I am the person who is in.
But you can use reasonable force. 2:1 says that the person executing a warrant may use such reasonable force as may be necessary. So I would have thought that that includes the ability to enter the premises. Otherwise, the thing could be thwarted by the person just never going there, never being present.
I think in the context of the
provision, you know. Now, I'm trying to find out if that is a normal provision in search warrants, that you can execute a search warrant when no one is on the premises.
So remember, I think what, in the context of the provision that you just read, what we see this as is if there is a gate, then you could open the gate and leave it on, let's say, the front, the door, or the door of the premises and you can leave, because maybe if you leave it on a gate, nobody would see it. So you want to leave it somewhere that they would see it, but I don't think it means you break the door down while the person isn't there and access but it's for purposes of allowing the person who is issuing the warrant to actually leave the notice somewhere that the occupier will see that notice.
Perhaps then, if I may, maybe there needs to be some rewording of the provision. If that is the intent, Ms. Murray, if the intent is just to notify the occupant that there is a warrant to be executed, as opposed to executing the warrant in the absence of the occupant, then I think perhaps we need to reword it, unless my reading of it is incorrect.
So, Madam Solicitor, Chair, Madam Solicitor General, what is the standard in law for warrants and absent subjects? What does the authority do generally?
Sorry, the laws do provide for different things and nuances. So it's hard for me to say that there is a standard, because if you look in the different laws, you will see variations of the theme. But the whole point of a search warrant, you don't give advance notice. You don't give advance notice. So you would be going to the property to execute it. We have put in safeguards here. So for instance, it is supposed to be executed at a reasonable hour. So there are certain safeguards that are built in, but this will still allow for the warrant to be executed if the occupier is not there, because otherwise it would defeat the whole purpose of the search warrant. So the issue, I guess, would be for the committee members to look to see if they think that there are enough safeguards put in, noting that there are fundamental rights and freedoms that could be infringed.
And perhaps you can give me some assistance here, Madam Solicitor General. In the case of a premises that's locked, not because you're evading, but you're just closed for whatever the reason, you're saying that this allows the person executing the warrant to enter upon that premises, seize what is to be seized based on a provision in the law, and leave a list or a copy of the documents or that which have been seized. And you're saying that that is not an unusual provision?
Unusual meaning if it's not in any other law? I can't tell you that it is worded exactly the same elsewhere, but we do have examples. I can't give them to you right now. I would have to look to give you an example of something that is similar to this. Normally, though, the reason we don't have a standard format is because it depends on the type of legislation that you're looking at. So, in fact, we have laws that allow for this to be done. And the search warrant, you go to a justice of the peace, not even a judge. And again, usually the reason you would even ask for a JP is because timing. Sometimes the urgency of the matter, the nature of the matter. And so this is the reason you don't necessarily have what I would call a standard format. So what is usually important is just to look in the law to see if you think that there are enough safeguards inbuilt to allow. So for instance, if I go back and I see that my door is broken and I now see that a warrant is there, I will know, one, who came into my property, two, what they took, and then I can then take it from there. So these are some of the safeguards that have been put in place in this law.
Is there, and I'm not suggesting a change, I'm just seeking for my own understanding. Is there anything in this that requires reasonable attempts to contact the subject of the search warrant? That would not be necessary, I suspect.
It's not that it's not necessary, it's just not ideal. If you have information, think of it from the perspective of the regulator.
Paragraph 1(7) on page 104, where the judge would, should not issue the warrant unless the commission has given 7 days notice in writing to the occupier of the premises in question demanding access to the premises, and either access was demanded at a reasonable hour or was unreasonably refused. And
so that answers the question. That solves the mischief, I guess.
So
there's no circumstance in this scheme that you could go in, you could go, as it were, ex parte, apply for the search warrant and execute it without first having notified the person that you want this, you want it.
Yes, that's in paragraph 1(9) on page 105.
1(9).
That deals with cases of urgency or where compliance with that notice would defeat the object of the entry.
Okay. Right. So in that situation, you wouldn't have to give advance notice.
Thank you for that, Ms. Murray. I just have another question. Hopefully you can help me. Page 106 at paragraph 3.5. Yes, paragraph 3.5. In this paragraph, references to the client of an attorney at law include references to any person representing that client. And I'm seeking some clarification because I read it twice and I'm not sure if I'm overlooking something. But I just wondered in what circumstance could someone...
What does that mean? That's an odd provision.
Yeah, I'm just trying to figure, apart from an attorney at law, who else could enjoy that privilege of lawyer-client privilege as outlined here? Paragraph 3, section 5.
Sorry, the reference there is to the client though, so it would include like an agent of the client. It's not to the attorney at law.
all right. All right, if there are no more questions, I will put clause 57 and the third schedule to the
Chair,
members.
sorry to be a annoyance, but why are we going so high to the? Have we decided whether we're going to the Supreme Court or leave it at parish just? Because I don't know why we would need to go to the Supreme Court for this. I mean, go all the way to the Supreme Court just for a warrant. I'm just asking, is it the parish court judges are not competent enough?
We agreed to go to the Supreme Court.
We have not, but the recommendation is there. I just want clarity.
We were simply putting it to the committee, and we'll be guided by the committee in relation to this. But what we had, or what we have in the bill is what is in the bill, which is a parish court.
Don't want Justice Sykes to question our clogging of his courts, you know.
No, and so we certainly have no objection. We just raised it.
If I may please, Chairman, I did have another question, Ms. Murray. On page 105, paragraph 2, subsection 5, which speaks to the seizure of items. And I wondered, and perhaps the Solicitor General can guide me here, but I wondered whether there needed to be a provision that allows you to approach a court for the release of these documents, or is it an automatic right that you'd have, or recourse you'd have? Page 105, paragraph 2, subsection 5.
Sorry, I can't answer the question now. I'd have to get back to you on that.
You have to get the answer on that before. Okay. So does that mean we can't move on 57 or what? Huh? 57?
I will come back with the answer. So
on 57.
If you want, you could move on.
All right. All right.
So we're staying in the parish court? Just carry.
Yes, we're staying with parish court. But there's a question that's supposed to come back, so we will
just wanted to
suspend 57. Are we ready then, SG, for 55 and 56?
Sorry, read the power of the court. Chair, that's what you
55, the right of appeal. I know you went outside to do some
Right,
research.
in terms of the power of the court. So I don't have the actual provision, but once there is an appeal to the court, the applicant could make an application asking for an injunction, a mandatory injunction, and there are rules that govern that. It's just that it's not automatic. The court has certain guidelines and parameters within which it will grant it, and for instance, it would never grant it if it is something that would defeat the purpose. So if you're asking for if the decision is to stop something, the court would only say consider it if it is something that can be done or restarted, for instance. So there are certain guidelines with which the court would take into account before granting it. But it is possible. It's just that there is a high standard to be met.
Yes, you don't consider that there would be any merit in making an express provision that will allow the court to grant a stay of the decision pending on such terms as it sees fit, pending the determination of the appeal?
There is merit. I would say maybe not the court. It could be another authority that could grant the stay.
I'm speaking in the context of an appeal to the court.
Oh, an appeal to the court.
Yeah, on the 54, on
Oh.
55 and 56. Yeah, 55 and 56.
Well, since there is case law that governs how the court can already operate, I'm not sure that that provision would say help, because the applicant already has that power, unless we're trying to say we want to alter the factors that the court would take into account, and that I would be very slow to agree with.
Well, I'm not proposing that we would alter the factors that the court would look at, but you mentioned mandatory injunction, and that is a notoriously difficult thing to get, whereas a stay is not generally as hard if the status quo needs to be preserved in the interest of justice. I prefer to see when you're dealing with things arising out of a statute, as opposed to appeals arising from common law causes of action. I like to see those sort of critical issues just expressly provided for here. But I'm not proposing that we change the kind of criteria and considerations, factors that the court would use to determine whether or not to grant a stay, because I'm sure there's learning on that. But
so I better understand what you're saying. So I would need more time to have a discussion with a litigator about that. What I was speaking about is already the inherent jurisdiction of the court right now. What you're suggesting may be something a little bit above and beyond that. So this is something I would have to discuss.
I could see somebody from the chambers taking a preliminary point on appeal, that there's no power to grant a stay.
I can report to the committee at the next meeting on this particular issue.
SG, for clarity, Chair, just the question, wanting to find out if one of the things we're going to be looking at is whether or not we should have an automatic right of appeal to the Court of Appeal from the tribunal, or is that what I just want to make sure, because I don't even want to use the reason why I'm interested in that conversation, but we have situations in our country where tribunals make decisions and persons are unable to exercise rights within the courts except on a matter of law, and I do not know if we want to continue that sort of approach. I will say no more on that.
And I'm sort of in a very difficult place, because I understand what the policy is. The policy here is to give the person a right to appeal to the court, but it is not usually generally the stance of the chambers. If you have another entity like an appeal tribunal, that is usually the approach we usually support, for many reasons, but we understand the policy, and so it's a little difficult for me to really answer your question.
The reasoning, and I was speaking to a member to my right, is that this is not a specialist tribunal, is it? It's not a tribunal of experts. It's a tribunal, an ordinary tribunal. An ad hoc was the word that was used.
I think ad hoc is just because it's not set up Monday to Friday, 7 days a week.
In the sense that for me, if it was a tribunal that was based on the criteria for membership, specific in relation to particular competencies, I would be more inclined. But past experience in my short years have led me to be very concerned about tribunals that have final say in terms of the rights of individuals without them having recourse except with judicial review, or I'm very nervous.
So I understand, and I mean, remember too, the committee has within its purview the right to also make some amendments to the 5th schedule, so you could make some amendments to indicate the types of persons you would want on the appeal tribunal, which would include experts in the area. So that is something within your purview that you can do. From another perspective, our concern is always expanding the remit of what goes to court, knowing, of course, how overburdened our courts are, and trying to ensure that there is some balance. Of course, we don't want to, again, have persons' rights be interfered with, and them not being able to find or to get what they would consider the appropriate, their time to have it properly considered before an appropriate entity, tribunal or court. But we aren't usually, from the Chamber's perspective, we don't usually encourage a lot of appeals, straight appeals to the court. Normally, the approach we support is if you have a tribunal, you use that entity and then you have judicial review. But again, I said, we respect the policy here, which is that you would be able to have some direct appeals to the court.
So we'll talk about it next time. Okay.
I mean, the fifth schedule really doesn't go into any detail as to the qualifications or experience required to be a member of the appeal tribunal, other than the chairperson, who must be a retired judge of the Supreme Court or Court of Appeal. But the other 4 members, because it's a 5-member appeal tribunal, you know, it's silent on what their qualifications should be.
So
but if the idea of an appeal tribunal is to avoid burdening the court system with adjudicating complaints arising out of this process of this data protection process, and if the idea is that, then I can see why it doesn't really make sense to give a right of a substantive appeal to the court, because in essence you're essentially shunting the decision-making power back into the court system, whereas judicial review is there as a safeguard in case the appeal tribunal has really acted unlawfully in how it's approached the adjudication of the case. So it, for example, didn't comply with the rules of natural justice in giving an opportunity to be heard to the parties to the appeal, or they acted ultra vires the statute in some way and failed to take some relevant consideration into account and so on. But if it's just that, boy, we don't like the decision they made and we want the merits of that decision to be heard by another body after they've done so, if you're going to give them that type of appeal, which is really a substantive appeal as opposed to judicial review, then essentially you're just going back into the court system, which the appeal tribunal is really set up to avoid doing. So I understand very well where the chambers are coming from, because we do have, the Court of Appeal in particular is extremely burdened at the moment. So, you know.
I was just going on to say, again, back to the 5th schedule. I mean, yes, we always agree that it's always good to give some discretion, but I still think you could give some guidance as to persons who have expertise in certain subject areas. Even that, I think, could be included in the 5th schedule to tighten the types of persons that you would put on your appeal tribunal. I think it would give persons a lot more confidence in that process.
Chairman, if I may, still on the 5th schedule, because we have not yet decided on the recommendation that was made, which I supported in terms of in terms of the appeal tribunal vis-a-vis the court. But if it is that the decision maintains that we should separate the matters that will go to court as opposed to those that will go to the appeal tribunal, I want to make some recommendations on the 5th schedule. I have had to appear before the appeals tribunal, the Access to Information Tribunal, and I'm quite sure it was more than half a year that I waited for a date. And I think the reason, I'm supposing that one of the reasons why we're trying to separate some of the matters to the court and the appeals tribunal is to lessen the time that persons have to wait to have their matters adjudicated upon.
And so I would want to see in the fifth schedule some specific timelines. I can't remember which piece of legislation that we looked at. Donna, I don't remember. Was it JACRA that has that you have to file by X time, and within X time you get a response, and within X time you have a hearing, and within X time you have a determination. So I would want to see that kind of detail being fleshed out in the Act if we're going to go that way.
The Access to Information Appeal Tribunal also has rules and timelines inbuilt. But there are other examples, the Revenue Appeals Division as well, and I think their rules are very specific and set out. And because it's tax matters, you know, you don't want those kind of matters drawn out. I don't know if we should hold up the ATI Appeal Tribunal as the standard. I don't think it is. I do recall the senator being on an appeal tribunal years ago, and that appeal tribunal did not have matters languishing for 6 months. But I agree that, but the thing is, some of those rules don't always have to be set out in the actual act, because you usually give them the, right, and I think this allows for the regulations to be made. What would be good, I guess, is just for the ministry to, you know, give an indication that they will be proceeding with doing those regulations as soon as possible. So you don't actually have to have it set out here, and this allows for the regulations to be made. And then maybe just some assurance can be given that there will be the tight timelines and all of that inbuilt. But part of the staffing and the resources of the tribunal is really a major issue. Outside of that, it's also who you put on your tribunal, and as Senator said off mic, it's also dependent on how the chair, which I'm now saying on the mic, but it's a matter of the persons that you select for your appeal tribunal. A lot of that goes into how that tribunal will work and how effective it will be. But I'm sure the ministry can give some assurance that these rules will be done in a timely manner.
All right, so we will defer clause 55, rights of appeal, and by extension clause 56, because they're related. We'll defer as well clause 57, SG, to come back to us, but we accept that it's the appeals court as per the third schedule. The parish court, sorry. The parish court. And we are deferring as well clause 70. 55, 56, 57. Right, 57, you were supposed to come back to us, no? Are you? Huh? No? We're good with 57? No? All right.
In relation to the third schedule.
Oh, in relation to the third schedule, we accepted the parish court, right? In relation to the...
Chair, we could take 57 because we can treat with the third schedule and the contents thereof separately. Yeah, but all right, yeah. Not true.
All right. So again, let me repeat in terms of the clauses that are deferred, members, clause 55, 56, 57, including the third schedule, 70, and the fifth schedule. All right? Agreed? All right. All right, we'll move on to clause 58.
There's no comment on 58.
All right, members, I know we're getting to the end. We're getting to the end. Clause 58, there were no comments, so I put it to the members. I put clause 58 to the members. There are no comments. Okay, we accept clause 58. Clause 59, data sharing code.
Just two comments, members.
On 58, just a quick comment. The mandatory codes are very important. They're not subject to any affirmative resolution type procedure like regulations would be. They're simply tabled. But
we're on 59 now.
58, 3?
Sorry, where are we? 58. No, but we put 58 because there were no comments.
I know, well, I'm asking to recommit it for one quick comment.
58.
Yes, ma'am.
Right, okay.
Yes, Chair. So I'm just saying that in relation, I have no issue with the annual reports and so on just being laid before, but the codes, if they are going to be the sort of operational document that economic actors have to comply with and they're mandatory, should they not be subject to the approval of the House rather than just laid before the House? Because they have legislative effect in that they're prescriptive and they are enforceable in law. So I just think there ought to be an approval process, not just a laying process.
So the function that is being exercised here is this function that the Commissioner has at clause 4, 5E, to prepare and disseminate or direct the preparation and dissemination to such persons or other entities as the Commissioner considers appropriate mandatory codes to be adhered to as good practice. And he will do that where he considers it appropriate and in consultation with trade associations, data subjects, and other persons representing data subjects. So it's something that he can do.
If you violate the code, what sanction is there or punishment? So they're not really mandatory. That's a misnomer.
And I think that, and I'm just not remembering which clause of the bill treat with it. It's treated more as a guide and will be taken into consideration when reviewing the actions of a data controller, because they're there as
mandatory suggested to me that they had legal effect and that failing to comply with them would result in some liability. But if they're really more in the nature of guidelines, that would be taken into account maybe in a decision on another issue, but then it's a different, I just think the word mandatory is perhaps misleading.
But just take into account, Member Golding, that on page 11 of the bill,
11.
So yes, 4.5E talks about the mandatory. If you go to F, then you'll see the voluntary codes. So I think, right. And I think the whole point is that there is usually discussion, consultation, and agreement in relation to these codes. So the question is, after these trade associations, for instance, all agree, if it were going to come to Parliament to change what these associations have already agreed, there may be I don't know about that kind of process.
Well, it's just that, many areas don't really have trade associations, and some that do, not all persons who are involved in that industry are members of the trade association. There may be more than one. I don't know. For me, it really depends on what the impact of this code is and whether or not it is binding. I mean, if it is in the nature of delegated legislation, then my preference would have been for it to be approved by Parliament as a code of law, in effect. But if it is not, then I don't have that concern.
Regime. So, members, what was intended here is really a kind of co-regulatory regime where you'd have the overarching piece of legislation that would guide the standards and the behavior of the, well, indicate the standards and guide the behavior of data controllers. But then within their individual sectors or trades, they could determine, and this is where you get the voluntary codes by which they're going to be guided, of course, all of which must comply generally with the legislation. And then the power that is given to the commissioner at clause 4, and specifically 4E, is that where it is that he or she determines that a particular sector, let's use for example the health, or within the health sector, or the financial sector, that there needs to be, or the data controllers within that particular sector need to have something to guide their practice, then he or she could mandate that that be done. And he could determine that he's going to prepare the codes himself, or a regulatory entity, whether, for example, the Financial Services Commission, maybe the Bank of Jamaica, could, in collaboration with those data controllers, develop their own mandatory codes, and then this is what they would now take to the Parliament and lay, so that everyone would know the standards by which they're going to be holding themselves and judging themselves. But it really is intended to be a co-regulatory type regime, where you have the primary legislation, and then within the context of the sector in which the data controllers operate, they would then guide their further operations in relation to the legislation.
Chair, I'd be interested to be reminded whether the codes under the Electricity Act are subject to any kind of approval process by Parliament. I'd be interested to know that. And I notice on page 85 there's a whole list of activities of instruments that require affirmative resolution, various forms of orders and regulations and so on. But if it's a mandatory code, to my mind it ought to fall within that list, if it's mandatory. And I like the way that they are developed and the fact that it's a participatory approach to developing them, but that still doesn't, to me, negate the importance of the Parliament having a final say on what becomes law, or people, typically under the Banking Act and the Securities Act and all the different sectorial areas that we're discussing, regulations in those areas are typically subject to some kind of parliamentary approval process as well. Even if the regulations, for example, are made by the Commission, by the Financial Services Commission, rather than the Minister just has to approve them, but they may still have to be approved by Parliament. So I would prefer that from a governance point of view.
And also what concerns me, if it's mandatory, how do you enforce this? What is the penalty for non-compliance? I'm not seeing that. And then when you compare that to the voluntary ones, it's not intended for there to be any enforcement, or what makes it mandatory? You could perhaps just share with us the thinking of the ministry.
There must be some difference.
In the context of the mandatory and the voluntary? It's a case of who and what which types of data controllers you feel the commissioner may believe, because it's a may, it's not something that he has to do, but if he decides to do, it must be a determination that he or she makes that there are a group or type of data, there is a group or there are types of data controllers that need to have established for themselves. They will establish themselves or I will establish it for them. Further guidance on good practice as to how to give effect to the legislation. So the breach of the codes may not in and of themselves, because they're likely to be operational, as they're likely to be operational. So it's a case of how do I take this bill or this act and operationalize it within the context of this sector. So where our focus is are you breaching the legislation and not necessarily a code? Because a code is a guide, it's a practice. This is how we've decided that we're going to be operating. And if you're breaching the mandatory code, then it is possible that you might be breaching the legislation itself, but you may not be. Because what the code is intended to do is to set guidelines around how, as a sector, specifically, you will operate in giving effect to what is required here. Because the standards will vary. Some persons are treating with sensitive data, some persons are not. We might want voluntary codes for, let's use a JITSA, which is a Information Technology Services Alliance, because what they're doing may not rise to the level of, or the processing is less than what would happen in the medical field or the medical sector or the health sector, for example. So what we're saying is that you will take this piece of legislation, and as a group of persons, you will sit along with the commissioner to determine how you're going to operationalize this piece of legislation and how collectively you are going to operate as opposed to individually. And that is what is intended by the practice.
The data sharing code in the provision we're about to go to.
So the data sharing code is different from the mandatory codes and the voluntary codes.
Okay, but it does require affirmative resolution approval under 59.4a. Yeah. I don't know why it's elevated to a higher level, because 61 says that breaching it does not of itself render the person liable to any legal proceedings in any court or tribunal. It seems to me anomalous that we have different standards of approval for different types of codes, when the one that requires the highest level of approval is expressly not itself legally enforceable.
I'm saying I take your explanation, but I just wondering if we should categorize them with mandatory and voluntary, because when somebody says something is mandatory, it connotes something that you must do. And if you do not do this, then there are certain consequences for not doing it. And I'm not hearing that from you, because it doesn't appear to me that that was a thinking of the ministry in terms of, putting some kind of consequences to it. So I wondered whether you should not just call it codes, and then within the internal operation, you can have them in categories. Just food for thought, and perhaps Chairman might be a good place at which we may end.
I think it's mandatory in one set as opposed to voluntary, because in this, with respect to this class of data controllers or this area of processing, the commissioner would have determined that it is desirable that there should be a code by which all of these people operate. Whereas the voluntary ones, the commissioner may decide that, having regard to the nature of the processing or the date class, that they don't necessarily need to have a code, but if they want to go ahead and have one, then it's fine. So I think it's mandatory versus voluntary in that
sense. And we're on the same page, but I'm saying if it's so mandatory, if it's so important that if the data commissioner says it is so important that you must have these codes, then the question is, what is the consequence of not implementing or adhering these codes, which you must have because they're so important to good governance?
I'm listening to your position and your yes. I suspect that in many spheres of business you have organizations where the membership would come up with standards within their organization, and I'm wondering if this is an attempt by the bill to really raise the level of respect that a sector, the commissioner would raise the level of respect that an organizational best practice may have by putting it in the house. But then the question is, if it is not mandatory, then what's the point of it? If it, in the real sense, if there are no sanctions associated with a rule, then is it really a rule of any consequence? That is the question. What happens to me if I do not, if my organization say I should have this practice and I don't do it and there's nothing to it, then what is the point of it really? You know, is it just moral suasion?
We'll Chair and members, we look at it, because, yeah. Yes, just consider. We consider it and come back. Yes.
All right, members, the time being 4:58 and 36 seconds. We will bring this session to a close. When we reconvene.
Chair, before we wrap up, you wanted us to look at where we're at and how long the weekly meetings are a bit burdensome. So I just wondering how many more sessions you think we need to complete and whether we can try 3?
No, not session.
No?
Well, we're at 59 now, and we go to actually,
there's some deferred clauses, 55, 56,
yes,
57,
up to
58,
77,
70,
noting and the schedules.
Yeah.
But noting that we have to return to a couple of clauses, as well as the fact that this matrix the comments here would have been in relation to comments that are specific to clauses. However, there were comments that were general in nature, and we haven't gotten to those yet. So, in fact, Chair, I will just share that we've prepared our comments on those, and we'll be sharing it for onward consideration. But that's another set of, which is not voluminous, but still there are some general comments that would have been made that we haven't addressed, because what we were doing would have been comments based on actual clauses.
So members,
Through the chair, if the comment is general to the bill and does not apply to a specific clause, then of what relevance it is to the discussion?
They're relevant because they're recommendations in relation to, for example, the introduction of new rights and so on. So we'd have to look at those. Yeah.
All right. So we bring this session to a close. The date of the next meeting is next Wednesday, November 6th at 2 p.m. Meeting is adjourned.
the pink balloon. October is Breast Cancer Awareness Month, and it will be recognized under the theme Give Hope, Save